to join us. It appears that I was on mute for a few seconds there, so I'll take that again. My apologies. Good afternoon, distinguished ladies and gentlemen. Welcome to the third edition of the Laciac Live Debates. My name is Babatunde Ajibade. I'm a director of Laciac, which is the Lagos Chamber of Commerce International Arbitration Center. And we're delighted that you're going to spend the next hour and some with us listening to a very interesting debate on a very interesting topic. The Laciac Live Debates were launched in July 2020, and they focus on developing and emerging trends and issues in international arbitration. They provide a platform for arbitrators and arbitration practitioners to reason and discuss these issues. We've had two previous editions. The first edition featured Professor Dr. Abdul Wahab of Zulfikar and Partners Egypt, and Jacob Grisson of Asafo & Co in France, with Ndanga Kamau as the moderator. And this focused on the motion, virtual hearings are good and should be mandated. It attracted interest from over 300 participants from different parts of the world. I actually take that back. Perhaps rather than saying good afternoon, I should have said good morning, good afternoon, and good evening, depending on what part of the world you're in. The second edition held in October 2020, and the motion there was investor-state dispute settlement is better for Africa and the Middle East than state-to-state dispute settlement. And the debaters then were Professor Dr. Naila Komer Obeid of Obeid Law Firm in Beirut, and Professor Dakwa Konde of the University of Oxford in the United Kingdom. And the moderator was Dr. Uchora Onwumaegbu of Arendt Fox in Washington, DC. That had over 200 practitioners in attendance. The current edition is the first to occur in 2021. And as at yesterday, we had over 300 practitioners registered to attend. So we're happy to see that the interest has been sustained and is growing. For today, I will not introduce the topic of debate. I will leave that to our moderator. Our moderator for today's event is Dr. Pontian Okoli. Dr. Okoli lectures in private international law and commercial law at the University of Stirling in Scotland, United Kingdom. He obtained his PhD and LLM from the University of Dundee in Scotland, where he teaches private international law and the law of business transactions. He's a fellow of the Higher Education Academy, and he obtained his LLB at the University of Nigeria, Nsukka. Having worked as a barrister and solicitor and as in-house counsel, a great part of Pontian's law practice and experience concern international, commercial, corporate dealings, and investment risks. His recent publications include Promoting Foreign Judgments, Lessons in Legal Convergence from South Africa and Nigeria. Pontian, I hand over to you.
Thank you very, very much indeed, Doc. Thank you very much for that introduction. And thank you to all the panelists. We have a very distinguished panel today. And my, my task is to introduce the debate motion just before we let the panelists begin to let out their arsenal on this topic. So first, we'll just say that the motion for today really is about the enforcement of arbitral awards that have been annulled at the seat. And the question is, should they be enforced, even though they've been annulled at the seat? And we have two distinguished panelists today. First, Professor Horacio Gregorio Naon, who will be proposing this motion that those awards should indeed be enforced. And we'll say a few words about Horacio. Dr. Gregorio Naon is an Argentine national, For those of you who don't know where Argentina is, it's somewhere around the Suez Canal. Just kidding, actually where the Pope is from. So it's presently an independent international arbitrator, a consultant on arbitration and business and international law matters. He is a former Secretary General of the International Court of Arbitration of the International Chamber of Commerce, and has been a practitioner in the field of international commercial arbitration and international business law. He has done this for the past 30 years. Dr. Naon has also been widely published in those areas, including a book on choice of law problems in international commercial arbitration in 1992. He also has lectured at, and does lecture at the Hague Academy of International Law on the same topic. Professor Naon is a distinguished practitioner in residence and the director of the International Commercial Arbitration Center of the Washington College of Law, American University, Washington, D.C. He's also a member of the American Law Institute, former special counsel with White and Case, LLP, and a former senior counsel with International Finance Corporation in Washington, D.C. He also holds an LLM and SJD from Harvard Law School. Indeed, in addition to those, he holds a Bachelor of Laws and LLD degrees from the School of Law at the University of Buenos Aires, and is a member of the Argentine Federal New York District of Columbia and United States Supreme Court bars. It is indeed my special pleasure, honor to welcome Professor Horacio Riguera Naon to this panel. You're welcome, Professor. Okay, and to defend the position, on the other hand, it's a very distinguished senior advocate of Nigeria. And just for context, senior advocate of Nigeria is equivalent of a Queen's Counsel in the UK. So I just thought to clarify that. Mrs. Funke Adekoya is a senior advocate of Nigeria and a partner and head of the arbitration practice at ALEX, a leading law firm based in Lagos with offices in Accra. She is dual qualified as a legal practitioner in Nigeria as far back as 1975, a solicitor in England and Wales since 2004. She has been in active legal practice for the past 45 years and presently focuses on acting as counsel or arbitrator in commercial and investor state arbitrations. Her appointments have been both ad hoc and institutional under the LCIA, ICC, and ICSID rules, where she has acted as sole party appointed or chair arbitral panels in disputes arising out of shareholder agreements, commercial contracts, licensing, or joint venture arrangements in the energy, natural resources, and infrastructure sectors. She is a chartered arbitrator of the Chartered Institute of Arbitrators and was a past chairman of the Nigeria branch. She is also ranked in Chambers Global and in Who's Who Legal Arbitration, also listed on the chairman's panel of arbitrators at ICSID, and is currently a member of the ICC Africa Commission. And I'd like to say, Mrs. Funke Adekoya, you're very highly welcome to this debate. And it's a pleasure indeed to have you on this panel. You're welcome.
Thank you, Pontian, and good morning, good afternoon, good evening, everyone.
Yes, and it's not very often I have a parched throat after such a long introduction. And I tell you what, everybody, this was actually a much abridged version of both bios. Thank you for sending the abridged versions to us. Now, the time has come. It's a moment of truth. As you would see, the first thing we do is we'll have a poll, which is about the motion itself. And the question, of course, is should the arbitral awards which have been annulled at the seat of arbitration, should they be enforced, even though they've been annulled? And that poll will be coming up just about now. And then we'll see where you stand on that position. Has the poll been administered yet? Okay, so the poll is just up now. Should arbitral awards annul that a seat be enforced by courts of other jurisdictions? So is it a yes or no, or it depends? And once that's done, we'll start. And while you're voting, while we give you a few seconds to vote, you can see, if you can see, well, I'm done in a red tie, and Dr. Jibade is done in a red tie, and you know what that means. It means we're here, we're very serious about this, but we're also happy that if you notice white spaces, white dots in the ties, suggests that while there's war, there's also peace. So we make space for peace as well. Okay, so we've got the results back. On this motion, should arbitral awards annul that the seat be enforced by courts of other jurisdictions, we have 3% saying yes. We have 41% saying no. And we have 57% saying it depends. I really like anything that has to do with it depends. You know. So let's see. Let's see where that takes us. So without further ado, I would like to call on Horacio. Please, the floor is yours to propose this motion. Thanks.
Thank you so much, Dr. Pontian. In the first place, thank you very much for introducing me. I am tempted to appoint you as my public relations agent since you did such a good work. Thank you so very much to the Lagos Chamber of Commerce International Arbitration Center for having invited me. It's an honor. And I'm very pleased to share this panel with Madam Adekoya. There are different ways of skinning a cat. I think that the best way to skin this cat is to look at what the New York Convention, the 1958 New York Convention on the Recognition and Enforcement of Arbitral Award actually says. I don't think it is a good idea to start philosophical considerations about whether there can be arbitral awards totally detached from national jurisdictions or awards which just live in some sort of a national arena in which they are exempt from any kind of controls. So let's look at what the convention says. And we have to start with Article 5 of the New York Convention. And that's where we find the term may. In other words, national courts are not compelled to go through what the convention says, Article 5.1, essentially, to conclude whether the award is going to be enforced or not. The underlying thought is that although Article 5.1e establishes that an award has been annulled in the country of the seat, it is more or less killed for the rest of the world. If you have the word may, that gives discretion to the judge to vote that way or the other. The problem with may there is that's the English text of the convention. The Spanish and French texts are not so conclusive. But in any way, may is part of the reasoning. If the National Court of Law may, then it is not compelled not to enforce an award that has been set aside in the country of the seat. And actually, if you go to Article 5.2 of the New York Convention, when it comes to whether an award may be enforced or not, it is really the Court of Enforcement which has total discretion to establish where the subject matter of the dispute was arbitral or not, or whether the public policy of the country of enforcement, how the public policy of the country of enforcement should be interpreted and applied, that really gives a lot of leeway to the discretion of the courts of the country of enforcement, either to judge whether the dispute was arbitrable or whether public policy works or not. But then we have to go to the other provision of the New York Convention that is relevant for this, which is Article 7. And Article 7, in its relevant part, reads as follows. Any interested party may avail itself of any right he may have under, in respect of an arbitral award, to the extent and manner allowed by the law or the treaties of the country where such award is sought to be relied upon, which also gives the idea that if the laws of the country of enforcement are more favorable to the enforcement of the award, then the award may be enforced primarily if the laws or the case law of that country is more favorable to the enforcement of the award than the laws of the country under which the award was set aside. And it is really Article 7, the one which has been more relied upon when the New York Convention applies to foster the enforcement of awards that have been annulled or set aside under Article 5.1e of the New York Convention. The main expression that you find in Article 5 is more subject to question marks because of the different approaches you may take into account in regard to that provision. Because, as I said before, in Spanish and French languages of the convention, the may is not so strong as it happens in the English language. But really, to have a more complete perspective of what happens, it may be a good idea to look at the case law. And I am going to make, because of time, just a reference to what has happened in France and what is happening in the US. And in France, you have the Poutre-Valley decision of the French Cassation Court, which says essentially that if under French law, an annulled award can be enforced, that enforcement must take place, irrespective of the fact that it was set aside in the country in which the award was rendered. The Poutre-Valley decision makes a reference to floating awards in an international arena, which is totally shielded vis-a-vis what national legal system may say, but I don't think that's the central part of the decision. And there is an interesting permutation under French law, because apparently this principle would apply even if the New York Convention is not there, even if the may wording of Article 5 is not present, even if Article 7 of the New York Convention are not present. And this is what happened in the Bechtel Dubai case. In that case, the award was set aside in the country of the seat. It was brought for enforcement in France, and the argument of the respondent was, the argument of the respondent to oppose enforcement is that there hadn't been yet a full exhaustion of recourses under the law of the country of the seat, so that unless there had been a final decision, finally deciding what was to be the outcome as to the annulment, then the award could not be enforced in France. And the attitude of the French court was to say that would be double exequatur, that goes against the French legal system in arbitration. So the award can be enforced in France, although annulled in the country of origin. So there are situations in which even if the New York Convention were not present, under French law, the enforcement of an annulled award could take place. So this is what I can gather from France. Let's go to the USA. In the USA, you have different decisions. The first one is the Kromaloy decision. And the Kromaloy decision made a strong statement in favor of enforcing an award that had been set aside in the country of origin. If I have still the time, I will summarize very rapidly what this case is about. In this case, there was an arbitration, the seat of which was in Egypt. The award was annulled by an Egyptian high court. And the reasons for annulment was that the arbitrators had failed to apply properly the applicable law. And why was that? Because when Egypt incorporated the ancestral model law or introduced legislation inspiring the ancestral model law, they incorporated a provision that is not easy to find in other national enactments of the model law. It says that an award can be annulled if it failed to apply the law agreed upon by the parties to govern the subject matter of the dispute. So the argument was that the arbitrators failed to apply Egyptian law as it should have been applied. Now, the award is brought for enforcement in the USA, and the USA judge, federal judge, who took care of the case, decided to enforce the award based on two arguments. One is Article 7 of the New York Convention, but the second argument was, after all, the grounds to set aside an award in Egypt are not in line with the grounds to set aside awards under Section 10 of the Fair Arbitration Act. This is what Kromaloy was about. But there is another case that I would like to refer to because it's the Baker Marine case, and this concerns Nigeria. And in this case, what happened was that the High Federal Court of Nigeria set aside the award for different and many reasons. Now, the argument was that even if that award had been set aside in Nigeria, it could still be enforced in the USA. And it is interesting to see what the federal court in the USA decided in order not to enforce the award. And that was to give credit and grant effects to the High Federal Court of Nigeria decision to set aside the award. And one of the arguments was comity. And that is an important argument. You have to provide comity to the decision of foreign courts of law. But the other arguments were not as convincing as the comity argument. What the Baker Marine Court tried to do was to differentiate its decision from Kromaloy. And the reasons given were not so convincing. One of them is, in Kromaloy, you have a US party. Here, you don't have a USA party. So we have to decide in a different way. The second argument was that in Kromaloy, the application to set aside the application to enforce the award came before the annulment of the award in the country of origin. And the third one was under Kromaloy, there was a provision precluding the possibility for the parties to resort to a national court of law to set aside the award, and that was not the case in Baker Marine. And I'm going to now to refer to the most recent decision I am aware of in the USA, and then I will briefly give my conclusions on all this. And this was the Comisa case that involved the enforcement of an award that had been annulled, set aside in Mexico, in the US. Now, that case, I'm going to summarize it very briefly. What happened is that this was an oil and gas operation in Mexico. And after 95% of the oil company having drilled or set up all the operations in Mexico, Pemex, which was the other part of the dispute, decided to fire Comisa from the case. Now, Comisa is a Mexican company. Of course, Pemex is the Mexican oil and gas state company, but Comisa was controlled by a Texan oil and gas company. So although the case was superficially an entirely Mexican case, there were really, in truth, some international elements into it. The issue was that this case had a provision called or considered to be an administrative termination provision in the contract, allowing Comisa to put an end to the contract. And Comisa resorted to that provision, terminated the contract, and of course sued Pemex for damages. Now, there was a first decision of the arbitral tribunal. Its jurisdiction was challenged to decide somebody that is labeled as administrative termination of the contract. And the argument was it was beyond its jurisdiction of the arbitral tribunal to make any determination about the legality or not of that termination. And the arbitral tribunal rendered a partial award saying it had jurisdiction and rejected the jurisdictional objection. The problem is that after that, the Mexican government did two things. Number one, it issued a decision entrusting to the Mexican courts exclusive jurisdiction to decide on that issue. And on top of that, changed the statute of limitations that applied was 10 years to 45 days, which really made almost impossible to challenge any decision that could have been made in that connection. But even more meaningful than that, it passed a new regulation saying that all interpretations concerning administrative acts were non-arbitrable and had to be exclusively entrusted to courts of law. And as a result of that, there was a Mexican court decision at the end of the day, removing the possibility of the arbitrators to make a final decision on this. And at the end of the day, annulled the decisions of the arbitrators. Now, the final decision of the federal court, the Court of Appeals, the Second Circuit, was to say, we have to enforce the award that was annulled in Mexico and deny the enforcement of the Mexican court decision that annulled the award. And there were different reasons given by the federal court. And the most important of the grounds was that not enforcing the award was to be against US public policy. And that really the decision of the Mexican courts of law led to the expropriation without compensation of the oil and gas operation in Mexico. Now, let me wrap up and give me my take on all of this. There is nothing in the text of the New York Convention preventing the enforcement of an award that has been annulled in the country of the seat, in the country in which the award is brought for enforcement. Article 7 of the New York Convention is very clear about that. But now, of course, this means that the courts of country of enforcement have discretion. Now, but discretion is not a blank check. discretion has to be applied in a reasonable way and has to be applied within certain constraints. One of those constraints is comity. But comity is a rule, is a practical rule. It's not an absolute legal criteria. And I think that both in Baker Marine and in COMISA, comity was administered in an intelligent way. In the case of Baker Marine, and at the end of the day, where is the intelligent way of administering? Really being careful in examining the merits of the annulment decision. What I gathered from Baker Marine, and Dr. Adekoya, I'm sure knows the case much better than I do, is that apparently the Federal Court of Nigeria, the High Federal Court of Nigeria, had done a good job. They had looked carefully at the facts and the law applicable and came to the conclusion it was a good decision. Everything else is just legal argument. In the case of the COMISA, it was quite clear that what happened in Mexico, the retroactive application of the law to something had been already decided by the arbitrators in accordance to the legal framework that the arbitrators had when they decided the case. And so, comity or not comity, a good court will decide in the way it should decide. Thank you very much.
Well, thank you very much for that truly phenomenal proposition. Professor Nawan has been proposing that such award would be enforced and has taken a detailed excursion into the provisions of the ancestral law generally, and has looked at the case law in several jurisdictions, including France and of course the US, where we've had quite a busy judiciary on this up until last year, or 2 years ago, I think. So thank you very much, Horacio. That's truly phenomenal. We'll just quickly note for those who are joining, I noticed that there are quite a few number of people who have joined since we started. So it's the same event. It's the recording goes on. There was a poll earlier on at the start, and you had some people who said yes, no, and some said it depends. And it depends was actually up to 57%. And now we'll be handing over to the defendant, as it were, who will try to convince. But she's already had a head start because. For some reason, you had up to 41% saying that they actually would support that position. That is Mrs. Funke Adekoya's position. So let's see if they will change their minds after we hear the defense. So please, Funke, you have the floor for the next 10 minutes or so.
Thank you very much, Pontian. I take the view that awards that have been annulled at the seat should not be enforced by courts in other jurisdictions. And I'm going to start by saying, why is it even a big issue? Why are we even discussing it? The two largest awards in recent times are going through the same scenario. UCOS, $50 billion PCA award, initially set aside by the Dutch court, being enforced, or attempts being made to enforce that award in other jurisdictions. And if my recollection is correct, it has since been overturned. The initial Dutch court decision has since been overturned, and the Supreme Court in the Netherlands has since reinstated the award. Then again, UCOS, ICC arbitral awards, 4 awards by the shareholders, brought by the shareholders of UCOS, set aside at the seat, which was a Russian court. And those UCOS shareholders are in various jurisdictions all over the world trying to enforce that award, even though it has been annulled at the seat. PNID and Nigeria. Nigeria says, we are the seat of the arbitration. disputed by PNID, but Nigeria went to court in Nigeria, applied to have the award annulled, was successful in getting it annulled. But presently there are proceedings in the UK and also in the US seeking to enforce that award. So the question of whether or not annulled awards should be enforced in other jurisdictions is actually currently in the international spotlight. So where do we go from there? As Horatio has said, those who seek to enforce annulled awards, when they go to the enforcing jurisdiction, they waive the New York Convention. They point to Article 5.1e, they point to Article 7. And 5.1e, as Horatio has pointed out, at least in the English version, says maybe. So it grants a discretion, may be enforced. And Article 7, in essence, basically grants, states that no party shall be deprived of any right to benefit from an award as permitted by the laws of the enforcing states. And this is the position that France has taken, relying basically on Article 7 and saying, well, in our jurisdiction, we are not concerned with the annulled award. We're going to look at it from the point of view of French procedural law, and has actually set itself as a state where annulled awards are most likely to be enforced. But where do we go from there? As Horatio has pointed out, the issue really is that the enforcing court has a discretion. And he's also mentioned Committee of Nations. And my view is that the fact that an award has been annulled in one country and a person or a party is dissatisfied and then seeks to go to another jurisdiction to try to enforce the award that has been annulled is a clear statement by the enforcing party that I dispute the legitimacy, the ability, and the jurisdiction of the annulment court to give the decision it has given. And I'm therefore asking the enforcing court to exercise its jurisdiction and grant and enforce that award. This is a direct challenge to the Committee of Nations principles, which says that state entities in one country, whether they're legislative, executive, or judicial, should recognize the decisions of each other's jurisdictions, except it really becomes impossible to do so, or it really becomes difficult to do so. So while it is not 100% principle that Committee of Nations should be enforced, I would say that there is a 95% basis for states to expect that their legislative and other judicial acts will be recognized in other countries. So now let's exactly look at what 5.1e says. It says recognition and enforcement may be refused only if. And then it goes on to say in E, the award has not yet become binding, which is not what we're looking at, or has been set aside, which is what we are looking at. Also, it goes to talk about suspension. But for our purposes, the enforcing court may. So the may gives a discretion. And in my view, courts have used this discretionary power to determine whether or not to enforce the annulled award. And in doing so, they have gone on the basis of exercising their discretion based on what are stated in various judgments with public policy considerations. So let's talk about public policy. I think any common law lawyer is very aware of the statement made as far back as 1824 by Burrow J. in Richardson and Mellish. And he says, public policy is a very unruly horse And when you get astride, you never know where it will carry you. And I will also look at some of the cases that Horatio has mentioned, where public policy and the exercise of discretion has landed us in various directions. So my view is that this discretion has itself become the unruly horse. All the legal scholars and a review of case law generally in the English courts and also in the courts of the Netherlands show that ordinarily the courts say, we will respect a foreign decision that annuls an award, unless that decision is found, and I quote, to be contrary to basic principles of honesty, natural justice, or domestic public policy. These are the grounds that the English courts and the Netherlands courts have said will determine whether or not they would enforce. And my question is, who determines the standard of honesty or the standard of natural justice? And who determines whose domestic public policy should be reviewed and by whom? If the judge who is reviewing wakes up on a bad day and has certain thoughts, he could easily take a decision as to the standard of jurisdiction or the standard of natural justice in the annulment court. And the result of this is that we've had so many decisions that speak to different things. And I'm going to look at the UCOS capital cases as part of it. There have been several awards coming out of UCOS. And several of those awards have been recognized and have been enforced by courts in England, notwithstanding that they've been set aside in Russia. And the English court actually rejected the argument, which Horatio mentioned in passing, that the awards no longer existed legally because they had been annulled. And this is one of the theories as to whether or not enforcing courts should recognize annulled awards. The English court said, no, we're not persuaded by the argument that an annulled award no longer exists. The argument of the English courts was that the annulment, and I quote, was a result of a partial and dependent judicial system. And it therefore would disregard the annulment in the enforcement proceedings and take its own view as to whether or not that award should be enforced. The Dutch courts also have taken a similar position, similar to the English courts in respect of the UCOS awards, also basing a determination as to whether or not those decisions should be enforced on the state of the judicial process in Russia. In effect, both the English courts and the Dutch courts are sitting on appeal over the judicial system of another jurisdiction. And this, to my mind, is totally contrary to what Committee of Nations is all about. Then I'd also look at Maximov and OJSC, which is another case. And in this case, the English court refused to recognize and enforce an arbitral award, still coming out of Russia. In that case, the English court had a different test. Its test was whether the decision was so extreme and incorrect that the courts could not have been regarded as acting in good faith. Same legal system. Now it was not a question of being dependent or partial. It is a question of, was the legal system in Russia, was there evidence that the legal system in Russia was somehow biased, wasn't acting in good faith? So in that case, the English court said, well, it's been annulled in Russia. We are not going to enforce it here. Now let's look at some of the decisions in the US. The US do tend, and I agree with Horatio, do tend to uphold the committee principle, although there have been other decisions that have not. But Getma and Guinea, in 2017, the US courts basically said, we will uphold the annulment of the award in Getma and Guinea, having been annulled by the CCJA, even though we had some, I won't say disagreements, or even though there were some issues perhaps with the arbitration process, but that the US District Court said there was nothing that was shown to them to show that the standard used by the CCJA was repugnant to the fundamental notions of morality and justice. Even though this is an acceptable position, discretion then allows the court to talk about repugnant to fundamental notions. Whose notions of what is just and decent? Is it the notion of decency and justice of the United States, or the notion of repugnancy, decency and justice of the UK or of Guinea? So this discretion is a very unruly horse, and we don't know where it's going to take us to. And then I think I'm mindful of time, and I'm going to still touch on the Pemex case, which Horatio also mentioned. And yes, the facts are as stated in the Pemex case. In that case, the US courts actually held that to defer to the Mexican court's annulment would run against the US public policy in favor of enforcement. So in this case, in Pemex, the US court actually says, we will enforce unless there is something so totally contrary to our public policy. And once you've taken that view, then what's the purpose of even having annulment provisions? That seems to be my position. The US, and I think I'll just end with Kromalloy, where in Kromalloy, the US courts decided that they would not comply with the annulment because the annulment court had gone into a detailed review of the case on the merits in circumstances where parties had waived the right to any review. So still, in essence, what has happened is that we then have an enforcing court which sits in some kind of appeal over the decision taken by the annulment court. In conclusion, what I'll say is because 5.1e has been drafted in a permissive manner, the New York Convention grants enforcing courts a discretion. I agree. My position is that this discretion should not be exercised in favor of enforcement because the result is uncertainty as to the status of an annulled award. In fact, there is only one certainty as a result of 5.1e, and that is that an annulled award means nothing insofar as it can be enforced in other jurisdictions. When you even look at the different standards that different courts have adopted, and sometimes different courts in the same jurisdiction, it shows that there is so much uncertainty as to the basis upon which that discretion would be exercised to enforce. In some cases, they have said the annulment procedure is tainted with irregularity or contrary to the basic principles of natural justice and honesty and fairness. Those are the cases that are coming out of Russia. Also, some courts have said there's a public policy or other local standards of review which they have relied on. The annulment court has done a substantial review of the merits when it's not supposed to have done so. That's Kromalloy. The essence of it is that there's so much uncertainty. The whole essence of going to court or going to arbitration is to put an end to a dispute and have a decision. Now, if we end up with a decision that is not certain, then what's the whole purpose? Why even have annulment procedures if the annulment procedures do not count for anything? So in my view, courts in enforcing jurisdictions should be guided by a pro-arbitration mindset. That pro-arbitration mindset should give due deference to party autonomy. Party autonomy has selected a seat or provided principles for how the seats of the arbitration should be determined. And the enforcing court should give full weight to that party autonomy which has selected the seat, together with the consequences that can result from any annulment proceedings at the seat. For these reasons, I think that and annulled awards should not be enforced elsewhere. Thank you.
Okay, and the learned senior advocate rests. Okay.
I rest.
Okay, thank you so much. I think I warned you. You know, I donned a red tie today because it's such a serious issue, and but of course, Funke, you've been so gracious, and I could now see why you wore a bit of white, because you adopted a balanced approach. In fact, when you were talking, I did remember some scholars who had suggested a sort of balanced approach, talking about a supranational court to determine how to rein in those uncertainties you talked about. But very soon, I'll leave this matter to Horatio. But just before I go to Horatio to come back on a rebuttal for a couple of minutes, I thought I should leave it up until this moment. So I would like to let everybody know, now you've heard the main arguments of both distinguished panelists. It's time for you to begin to come up with your questions. We would very much like to hear your questions, whether you're for or against, or you're sitting on the fence. Just make sure it's on the fence, not in the Suez Canal or somewhere. All right. Okay. So I will now hand over to Horatio. If you want to, just in a couple of minutes, perhaps identify one or two key issues you have a few words to say, and then we will come back to the other side. Thank you very much.
Thank you very much. I think that Ms. Adekoya agrees that at least under the New York Convention, Article 7, there is discretion. So in principle, if there is discretion, at least under that provision, it means that indeed Article 5.1e has not the possibility of seeking total application or strict application, or even application at all, in a situation in which under Article 7, the Court of Enforcement exercises its discretion to enforce the annulled award. So at the end of the day, it's an issue of how you exercise your discretion. And I think that in that respect, we agree. I was very clear in saying that the court has to be cautious in exercising its discretion. And this is why I made the point of Baker Marine and of Comisa, because in both cases, the perception was that the court of the city didn't get it right. Now, in the case of Comisa, I want to make a very important clarification. Comisa was not a case under the New York Convention. It was a case under the Inter-American International Commercial Arbitration Convention, which does not have an Article 7. So the real exercise that was carried out by the Comisa court was to say, number one, should we enforce the court decision, the Mexican court decision in the USA? And that was the real public policy issue at stake. It was the enforcement of the court decision that had annulled the award. By denying enforcement of that court decision, automatically the award became enforceable in the USA. And really the reasons not to honor the public policy reasons that were at stake was to say, it goes against the US public policy to enforce the Mexican court decision. Because, among other things, it goes against public policy, and public policy was defined in the way that the case cited by Ms. Adekoya, along the same way, it goes against basic fundamental principles of decency, of what is considered as decent and just and fair in the USA to enforce that court decision. So let's understand exactly what is the environment. So at the end of the day, we agree on discretion. A committee to enforce a foreign court decision has its limitations. It's a practical rule, as the Comisa Court of Appeal decision decided. So at the end of the day, I don't think we disagree. The only thing is how do you exercise your discretion, and that goes case by case. And there is not an absolute principle, really, that Article 51E has to be enforced as is in all cases. So those are my comments.
Okay. Well, thank you very much. I think, Horatio, I think it's actually the case-by-case issue that Funke is not very happy about. So,
yes, but if I may add on that.
Yeah.
But that's the way the world is today. The purpose of the New York Convention is to foster enforcement of awards. Article 7, at least in the New York Convention, vests the national courts of law without discretion. You cannot ignore what the law is about. You can improve it, you can change it if you want, but the law is what it is.
Okay. Well, thank you very much for your very clinical rebuttal. From where I stand, I still see the edifice of the defendants standing really tall. So let's see how much of that is left when she comes back. I just want to quickly add before we have the last rebuttal by the defense. Please, if you have questions, and some questions are already coming in, I think, please put it in the Q&A box. That's where you have your questions. We're only able to take written questions. So please send your questions in while we wait for the rebuttal. Please, your questions to the Q&A box. Okay, it's a chance to hear the final rebuttal on this point. You have the floor, please.
Thank you. When Horatio was speaking initially, he spoke about floating awards and said that he wasn't going to go there. But I think that the question of floating awards is actually at the essence of allowing this discretion to be exercised. Because once you say that the award is international, it's not tied to any jurisdiction, you totally eclipse any relevance that an award has to the seat of arbitration in terms of procedural oversight, which includes the power to annul the award. And so the discretion that is being exercised, whether it is under Article 5 or under Article 7, comes against that background of a delocalized or a floating award. And I think that that's a wrong principle. An award doesn't float, and it is not delocalized. It is attached to somewhere. It's attached to the seat. If it were not attached to the seat, why would we have to determine where the seat of arbitration is in order to understand which is the supervising jurisdiction for the proceedings? Then secondly, I think that if we go back into how the New York Convention came about these provisions, my understanding is that it was to avoid a double executor provision, where you first of all had to go to the annulment court and get a confirmation of the award before you headed off to have it enforced elsewhere. And that was why the may was put into it. If one goes back into that, and if my understanding of the preparatory discussions in drafting the New York Convention is correct, then in essence, what the drafters were looking at was not to discountenance the annulment court, the court at the seat, but to ensure that it would be somewhat easier to enforce the award elsewhere. To that extent, I still take the view that yes, because we are not talking about changing the New York Convention, it is what it is. And what it is an enforcing court has a discretion. I just believe that enforcing courts should give more weight to a pro-arbitration mindset based on a finality. For now, discretion, it depends on which court you go to. And so to me, that doesn't help the arbitration process. as we can see from what's happening in all the various UCOS awards, being set aside in some places and enforced in other places. Courts of appeal are then overturning enforcements, overturning annulments. That's my view.
Okay, well, thank you very much. And I'm sure you would agree with me that we've had quite a very, very interesting, intense indeed session, and excellent points on both sides. Well, we're at that stage where it's a moment of truth, where we'll begin to find out what people have to ask in terms of their questions or clarifications. Some questions have come in. Some are just happy to say, well, this is really good, all the way from the Bahamas, for example. So, well, thanks. But we'll just focus on, well, thanks for making us feel like we need a holiday, Bahamas. So I'll just focus on the questions. A couple of them, not surprisingly, have concerned the P&ID case. So I'll just take one that seems to be quite comprehensive and see where that takes us. And it's does the manner of determination of the seat have any bearing on the views of the debaters? So would the fact that the parties have specified a seat in their arbitral agreement make any difference at all to the exercise of the discretion under Article 5, sub-Article 1, paragraph E, as against a situation where the determination of the seat has been the result of a judicial determination, for example, as was the case in the celebrated or infamous P&ID case? And we'll probably just, what do you think about that, Horatio? You're on mute. Yeah, that happens at least once in any virtual event.
I'm sorry. I should have sufficient experience by now not to make that mistake. but in any case, well, if you look at Article 7 of the New York Convention, it gives clearly the possibility to the enforcement judge to look at its own legal system of international arbitration and come to the conclusion whether that it should exercise its discretion to enforce the award annulled at the seat. So in principle, the fact that it was annulled at the seat does not per se play a role, but as I think I made clear, in the two cases I have referred to, Baker Marine and Comisa, the real analysis was the quality of the decision of the court of law at the country of the seat. So in an effort to make a just decision, and we are not talking now about the legal arguments, there are legal arguments in support of the just decision. They said, well, the decision in Nigeria was a good one. The annulment was properly made. In Comisa, the decision of the Mexican court was obviously in favor of Pemex, which is a state oil company. And I'm talking about the policies behind. So let's not enforce. But what was at stake was not the enforcement of the award in both cases, it was the enforcement of the court decision. And the final decisions in both cases was in Baker Marine, when enforced the annulment decision of the Nigerian High Court. In the Pemex decision, we do not enforce the decision of the Mexican Federal Court. And Article 7 in the case of Baker Marine allows you to do that. In the case of Comisa, there was no Article 7, but what was really at stake was the enforcement of the court decision and annulling the award, because the court decision annulling the award with or without Article 7 was not acceptable for the reasons given by the Court of Appeal of the Second Circuit. Then The consequence, the corollary, is that the award is enforced in the USA. So what is decided in the site is very important, but it's not determinative.
Okay, just before I come to the defense on this, if I may press you just for a moment, Horacio, would your view be any different at all if, first, I mean, there's a general conceptual issue which sometimes we tend to gloss over because it seems so basic, but I mean, it's the argument that there's, well, nothing comes from nothing. You know, there's just nothing to enforce. It's an empty shell argument. But what I'm more interested in is, would your position make any difference if it's also a function of how far gone up in appeal, for example, in the original jurisdiction? So, for example, if that matter was not merely a high court matter, but the parties had a chance to take that further up in appeal, or either to the Court of Appeal or to higher court, would that strengthen your view on the enforceability of annulled awards, or would it make no difference at all for you? It's something which I will also ask Funke, but I just thought I should hear your view on that as well.
Well, if you talk about the effectiveness of the award, at least and in many legal systems and under the New York Convention, it suffices it to be binding. And it becomes binding as soon as the award is rendered. So, and I'm not talking about the decision of the court of law. That's a different situation, and I'm not addressing that. But in terms of the bindingness of the award, you do not need to wait for any final determination as to its validity or not.
Okay. Well, that's fine. Now, only, and I'll come to the defense just now. And the reason I asked that was simply because the arguments we've heard in terms of the defense is really about the fact that there's uncertainty. And some authors, some scholars have wondered if that uncertainty could be bridled by looking at a number of other considerations, because it's really about the integrity of the original jurisdiction sometimes. And you're wondering whether that could be mitigated if there's evidence that they've gone a step further to really test and see that it's not just a decision, enforcing an arbitrary decision that hasn't had the benefit of extra pairs of eyes, if you like. But there's a specific question, if you just sort of reflect on that, Funke, there's a specific question for you. And I'm sure you like this one because it has something to do with comity. So the question there is, it says, surely comity is not an absolute bar to enforcing an annulled award, but only a factor to be taken into consideration in exercising discretion. This seems to be agreed by both debaters. Now, if that is the case, what is the relevance of party autonomy? So the concern here really is, you refer to party autonomy, and this questioner is wondering, well, what's the point? Because when you exercise party autonomy, you really have to recognize the existence of the discretion of the enforcing court, which is what Horacio had said earlier. I think the point is, you cannot on the one hand benefit from party autonomy and gain the benefits of arbitration, and on the other hand, perhaps when it's convenient, say, well, we'll ditch it.
Yes, I did say that party autonomy was not 100%. It was a very strong and weighty factor. So it was, I think I said 95%. It should be party autonomy should be the, committee should be the guiding principle. So yes, there is a 5% where perhaps for one reason or the other, one country would not uphold either legislative or judicial decisions of the other party. But where I link that to party autonomy is the question of the annulment court and the enforcement court. And my view is that, yes, parties in agreeing the seat, and therefore for me, where parties have agreed the seat, it has more weight than where the seat is the result of a judicial decision. And it is not clear in the arbitration clause of the arbitration agreements where the seat was to be. But where parties have agreed the seat, in my mind, the enforcing court should give due deference to that position. And if the award has been annulled at the seat, which was the seat chosen by the parties, the parties chose that seat and its legal system. And therefore, for an enforcing court then to review the legal system and then refuse to acknowledge the annulment, either by saying the procedure for annulling the award was less than perfect, or by saying, well, it's a floating award. The fact that if I don't countenance the annulment, it comes before me as a fresh decision, is different from party autonomy in respect of an enforcing court, because you don't know where the award is going to be enforced at the time you go into the process. Yes, parties do recognize the discretion that the award can be enforced anywhere where they have assets, but they're more concerned at the time when they're choosing the seat of saying this is the jurisdiction that will bind the award proceedings.
Okay, well, thanks very much for that. I think there is another question, which, if you don't mind, well, what can we really do to ensure certainty and predictability? Just for laugh, actually says, let's avoid the linguistic acrobatics and semantic jugglery, and let's know. Let's know. I might very well add jingoism, perhaps, but while we're at it, since we're doing some poetry, but I think the question really is, how do you ensure certainty and predictability? And I think it's a good question, because at the end of the day, this person is wondering. I think that's more towards Funke's position, but I think I really want to hear Horacio on this, because he is advocating, the position that such awards should be enforced. And do you think, and I know you've made a case to accept the fact that discretion is part of the process, but just on a final note, on that final note, do you think, in fairness, that there's any real issue there, and how can that be reined in? And that will be the final point, I think.
If I may, well, I think there is obviously a real issue. The examples that we heard from Ms. Adekoya on the UCOS is a good example. Of course, there is a real issue. But the problem is, what are we doing here? Are we going to be policy makers in an ideal world in which all the countries are going to agree on a new New York Convention or something equivalent? I think that is, the crystal ball doesn't allow us to reach such a wonderful solution. So we have to live with what we have. And what do we have? We have a world divided into countries, national states. The Article 7 of the New York Convention clearly allows for that discretion. Different courts of law say we do have the discretion. And an example of that is COMISA, that can be exercised in a way or another. In Baker Marine, it was exercised in a different way. So it's very difficult to give a wonderful solution. I think that the best solution is to have good judges who exercise discretion wisely. And I haven't seen, well, we see the situation described by Dr. Adekoya in UCOS. I have not been analyzing each of those court decisions and see if discretion was exercised wisely or not, but that's the world we have. And I don't have a magic formula to put an end to that lack of certainty.
Okay, well, thanks for that. And while we are on that, is it fair to say that that's your a closing remark, or do you have a word or two to add, and then we conclude the closing remark on your part, and then we come back to the defendant to also hear the closing remarks. Have you any extra thing to add just to close that, wrap that up, Horacio?
No, just to thank you again for this wonderful opportunity to discuss these things. I think it's comes from some Shakespeare play. Now all my charms are overthrown. There's nothing else that I can add. And I'm sure I cannot rival with Dr. Adekoya's charms.
If I may return that Shakespearean quip with equal gusto, since we're talking about the exercise of discretion, I would say a man, proud man, dressed in a little brief authority, he plays such fantastic tricks as make the angels weep. And
I'm sorry, I have no quotes, but I have.
Hopefully, we'll be exercising discretion in a way that will make Funke happy. But we have a chance. We would like to hear, what you think at this stage. What are your thoughts in this final address we've heard from Horacio, in and out of war, as it were, and now we have a chance to lower the temperature. And what do you have to say as your last word on this?
My last words are that there's work to be done. We've had the codes, the guides that guide the arbitration process, soft law, and it might be a good idea for either the arbitration community or the world community of jurists to prepare guidance principles on the exercise of discretion, on what constitutes conduct that is contrary to international principles of honesty and due process. And perhaps that would then grant some certainty as to what annulled awards are will be or will likely be enforced. And will that also grant guidance to annulment courts to ensure that if they do annul an award, it would be upheld elsewhere. Otherwise, I also thank Laciac for this opportunity. It's been a great debate, so I have enjoyed myself tremendously.
Yeah, thank you.
And my views are not necessarily the views I would take in real life.
Yes, thanks for the disclaimer. always helpful to have a disclaimer there. So yes, indeed, I'm absolutely excited to have had a chance to share this panel over the past hour or two. And I think it's an excellent job. The audience would agree with me and everybody else. It's truly an honor to be involved in this, not just because it's Laciac, although very much because it is, but also because it's a very important topic. The whole purpose of going to arbitration is to get the job done and to get fruits for your labor. And if you can't realize the fruits of the arbitration, then what's the point? And that's why it is a very, very important topic. And as you have heard from the panelists, I think there is a rapprochement, there is a meeting point between both sides, and it is that there is some scope to promote certainty. Some people have suggested, I think there was an Ecuadorian decision lately where the Constitutional Court tried to set clear standards for what criteria you could use to determine the annulment of decisions and all that. Maybe perhaps more things like that would put folks to ease and say, well, at the end of the day, the purpose of having this vastly successful arbitration award system, it has to be said, one of the most successful conventions in world history. Well, if it's not broken, why fix it? Perhaps some would say. So thank you very much. At this point, I have to hand over. My job is done, and I can't wait to take off my red tie because it's peace now, peace reigns, and everything is over. So thank you very much, Laciac. I'm handing over. Thank you very much.
Hello, everyone. Good morning, good afternoon, and good evening. And we'll administer the poll again just to see what the effect of the very, very lively debate we've just had. Please, can we put up the poll again? So we invite everyone to please indicate whether you think yes, arbitral awards should be annulled, arbitral awards annul that the seat should be enforced at the court of other jurisdictions, or no, they should not, or it depends. So Pontian, you're muted, by the way.
Mm-hmm.
Yeah.
So you have 51-46. I can do the comparison. When we started, just for context, you had 3% supporting Horatio's position. That has gone down to 2%. You haven't done too badly, Horatio, just 1% lower. But when we started, 41% were in support of the notion that they should not be enforced. And I'm sure Funke was so glad to see that she's recruited more supporters, and that has gone up to 51%. And initially, we had 57% say they were sitting either on the fence or swimming in the Suez Canal. And now they've decided that they want to go to dry ground, and that has come down to 46%. So I don't know, make of that what you will. I think it's for me, it's interesting that you have those who are undecided eventually taking a position. But I'm sure those people I'm also sure that those folks who have insisted that such a war should not be enforced, I'm sure they will not question the efficiency of the New York Convention anyway.
Absolutely.
Is something. I do think that Ms. Adekoya and I, in a certain way, we said it depends.
Yes, of course. Yes, of course. And absolutely. And that was how we concluded that there's definitely a meeting point. And I think both distinguished panelists agreed that there's always scope to introduce some certainty and predictability. Look, I'm not paid to have a view. If you want to know my view, Horatio has offered me a job, so maybe at that point you will know my view, but that's not my job. It's the job of the panelists. All right, thanks.
Thank you. Thank you very much, everyone. So my job is to say thank you, and I'll just get on with it. So on behalf of the Laciac Thought Leadership Board Committee that organizes the debates, and the Laciac Secretariat, I would like to extend very hearty thanks to our most valuable debaters, Mrs.
I think we may have lost Fumi there, but
it would be interesting to know how many people have been attending and how many people voted, isn't it?
Yes, yeah, somebody was asking how many people actually voted. That's for context. I think that's something which the Secretariat will be able to provide in due course. But we've lost Fumi. On behalf of Laciac is Doc here, perhaps to quickly conclude the vote of thanks on behalf of
Yes, I'm here. As we have lost Fumi, on behalf of Laciac, the board of Laciac, we thank our debaters. We thank Dr. Okoli for a wonderful piece of moderation. And we hope you will all join us for the next debate, the fourth in the series.
I apologize. I got caught off. Strange. Yes, but I guess, and then I also want to thank our supporting institutions, we must say. So to all the institutions who supported by promoting the series, to Mark in Mauritius, to Delos, to the New York International Arbitration Center, to Association of Young Arbitrators, Arbitrator Intelligence, to the Singapore International Arbitration Center, as well as the East Africa International Arbitration Conference. Thank you so much, everyone, for supporting us and promoting the debate. And then to you, our distinguished guests, ladies and gentlemen, it's been a pleasure having you with us. Thank you very much for your time. And just before I sign up, I'd like to encourage you all and invite you to continue to follow Laciac on social media and visit our website for more information on Laciac's activities. And then I look forward to seeing you at future events. So for me, it's goodbye and God bless. Thank you very much.
Okay.
Bye.
Thank you.
Bye-bye.
Thank you. Bye-bye.